The Supreme Court hears arguments today in a major case that threatens the multi-trillion-dollar tech industry. The argument is over a federal law protecting social media platforms from lawsuits over online content that they recommend to their users. Jan Crawford spoke with a mother who says she paid a very high price indeed for the tech giant's freedom.
10-year-old Nyla Anderson was always smiling.
That's her twin brother. And there she is as a baby.
She was Tawana Anderson's only daughter.
She was the life of my life. She was smart, she was loving, she was caring. She was a shining star, she was my butterfly. She was everything any mother can ask for.
Nyla died in December 2021 after attempting the so-called blackout challenge, which she had seen on TikTok. Like other social media outlets, TikTok's algorithms recommend videos and other content to users. Anderson said that feature led to Nyla's death.
They are actually feeding into our children. They are sending them videos that they never even searched before.
Anderson sued TikTok and has filed papers in a separate case now before the Supreme Court that for the first time could hold social media outlets accountable for some of the information and videos they are recommending to users. TikTok declined to comment on the lawsuit. The social media companies say a 1996 federal law shields them from liability and that the modern internet would not exist if companies couldn't sort and recommend third-party content to users. Free speech advocates say social media companies have rights similar to newspapers deciding what articles to publish.
People criticize social media platforms today, and they have the right to criticize them, but they don't have the right to legally force them to publish certain content, to not recommend other types of content, and so on.
But for Anderson and other grieving parents, they argue that has to change.
The funniest part about this, first of all, is that one, that's not true. It literally does happen in Europe. Some make sense, some are fucking annoying and weaponized against the left, like NetsDZ, that I have to deal with every day. But the funniest take is like, you can't fucking, you can't do this. The social media companies, even though they do it. And also, they even do it in America. They do. You monitor ISIS videos and shit, you know what I mean? You know that you could get in trouble, which is why you don't do it. And not only that, but right-wing broadcasters routinely bully platforms to show their content more. What are you talking about? Like, it's not an accident that like fucking psychotic right-wing content is not constantly being elevated on Facebook and everywhere else because they've been effectively cry bullying the tech giants, saying that if they don't actually get their content prominently featured, and despite the fact that it routinely fucking breaks TOS, that they will, you know, break up the fucking tech monopolies, which they should. I don't give a fuck.
Change.
How many more kids until they come to an end? How many more? That's my question to them. How many more children until this stops?
For CBS Mornings, I'm Jan Crawford in Philadelphia.
So there's a lot in that case there, and there are other related cases. You know, if terrorist videos are recommended to people, there was a case out in California where a federal officer was murdered after a social media platform connected two of the criminals who committed the crime. And the question is, should these tech companies be platforms that are neutral, passive receivers of all this content?
Should they be held liable?
Or liable when they start suggesting it, making connections, making
placing it in the algorithm,
we're
right?
in such an interesting time because we know as adults we can be influenced. So you can only imagine as a 9 or 10-year-old, which then becomes how do you sort of police that? Because the children need the technology a lot of times for school or what have you, but you almost have to, the kids are growing up so fast because you're addressing things like suicide and sex and, you know, at 9 or 10 because they're being exposed to it via social media or friends who have social access to social media. It's tough. My heart goes out to that mother.
Yeah, in reaction to that piece, any parent that has lost a child or any family member to social media or the pressures of, it's tough because, you know, my daughter was talking about that in her room, the blackout challenge.
Yeah.
And I remembered it because that was something that kids were talking about in elementary when we were younger. You know, hold your breath, and then that's my pressure on your chest. We had a conversation with her. And I'm just saying this because as parents, we have to be overly involved.
Yeah.
We have to be overly involved.
The key thing, though, the tech company's making money off the suggestion because they want to keep you on the site. The longer you're there interacting, the more money they make, right? Yeah. And so these lawsuits are saying, no, well, if you're going to push this, then you're going to be liable for this.
And
that's
the thing
the question.
that TikTok and Instagram and some of these things will say is, well, you're supposed to be 13 or you're supposed to be 16.
Right.
But obviously there's ways around that.
Now to Turkey, reeling this morning from another deadly earthquake, just 2 weeks after the massive quake that killed tens of thousands. Marcus Moore joins us with the latest. Good morning, Marcus.
Michael, good morning.
There's so much violent content on social media. I saw my friend's algorithm. He gets recommended gang shooting vids and all other sorts of insane shit. Yeah. One quick way to fix this is monitor what your kid is doing. Bro, come on. I mean, come on. Were you never a kid? My parents had no fucking idea. They were very strict with everything that I was supposedly seeing on social media or just on the computer in general, on the internet. You're crazy. I know someone in the chat just said people without kids love to say that shit, but they were kids at a certain point. Were you without parents? Did you never have like a guardian that fucking tried to stop you from doing something on the internet and that you totally went around it? You know what I mean? Like, come on, dude. That shit's crazy. My parents had 2 jobs. What the fuck are you talking about? Wait, what do you mean? You're telling me that? Because I do understand. Not that I disagree, but they're literally putting spyware on phones for child modes now. It doesn't matter. When there's a will, there's a way. Okay? If they're monitoring your activity, they're not monitoring your fucking friend's activity. You know what I mean?
It's just a sad update.
All right, before we get to the earthquake news, let's hear from Legal Eagle on
has
this
the potential
issue.
to end the internet as we know it. The internet flourishes on user-generated content. It's the backbone of the internet. And if you write or say something that is illegal, you can be held liable for what you said. But usually the websites that host your content are not liable. And when you hear about Section 230, this is usually what we're talking about. But if websites were also liable for what users say, then websites would either shut down almost everything or police things so tightly that there would be basically nothing even remotely objectionable. Because if there's one thing that websites hate, it's being on the hook for billions and billions of dollars of potential liability and attorney's fees. And this isn't just some potential hypothetical. In the past, when laws made websites liable for user content, they just shut down the content and never came back. And
DMCA.
one case before the Supreme Court this term seeks to do exactly that, but for all of the internet. No joke, this has the potential to end the internet as we know it today. So how did we get here?
How did I get here?
Well, it started with a tragedy. Noemi Gonzalez was a design major at California State University, Long Beach, who was spending a semester studying in Paris. On the evening of November 15th, 2015, she was dining with friends at a cafe on the Champs-Elysees when an ISIS terrorist with a gun opened fire. Gonzalez was killed along with 130 other people in coordinated attacks at 6 locations across the city. ISIS claimed responsibility for the attacks, and eventually 20 men were convicted of crimes related to the massacre. The lone surviving gunman was sentenced to life without parole. So, was justice served? Well, the Gonzalez family contends that it was not because there was another perpetrator still at large: YouTube. The family sued Google, which owns YouTube, alleging that YouTube's algorithms amplify violent videos and hateful content, despite the company's efforts to ban violent accounts and limit their reach. The Gonzalez family says that YouTube's recommendations expose people to hateful content, radicalize viewers, and encourage them to make terrorist attacks of their own. Google argued that because ISIS, not YouTube, made and uploaded those videos, YouTube was not the provider or developer of those videos, and therefore it was immune from liability under 47 USC Section 2.
Notice that this argument never really extends to right-wing radicalization, which is absolutely real and true. For the record, just want to point that out. I mean, Daily Wire, you know? I saw TD Max when I was in elementary school before my internet was even a thing. I had a Betamax player in my room with R-rated movies. Kids saw this stuff even before the internet. I don't buy the idea that we should be making platforms liable for recommendations. That's crazy. That means that they will stop independent creators and become walled gardens for major corpos. I agree with you. I know. I think that this sets a very shitty precedent. However, I do think that there needs to be a way to at least open up the door without complete control, without like genuinely fucking forcing every company to do exactly what you just mentioned, where companies do have to self-regulate like they are. Like companies need to fucking self-regulate. They need to abide by their terms of service. But isn't ISIS right-wing, not left-wing? Yes, ISIS is right-wing. And there is the American version of ISIS that was also popping off on YouTube and still is.
.230, otherwise known as Section 230 of the Communications Decency Act. Section 230 of the CDA immunizes internet services for the content that its users upload and often allows websites to remove content without taking on liability. But the Gonzalez plaintiffs contend that YouTube's recommendations should not be covered by Section 230 because the company is acting like a content creator rather than a publisher. The Ninth Circuit Court of Appeals held that the Gonzalez claims fell within Section 230 and Google was immune from suit. The Gonzalez parties appealed, and the Supreme Court granted cert to answer the question of whether Section 230 immunizes an interactive computer service from liability for recommending other party content. Now, in support of their claims, plaintiffs allege that, quote, 2 of the 12 ISIS terrorists who carried out the attacks used online social media platforms to post links to ISIS recruitment YouTube videos and, quote, jihadi YouTube videos. One of the men who fired at Gonzalez had appeared in an ISIS recruiting video in 2014. Now, the plaintiffs argue that the defendants violated the Anti-Terrorism Act, the ATA, by allowing ISIS to post videos on YouTube. Under Section 2333 of the ATA, as amended by the Justice Against Sponsors of Terrorism Act, Americans who are injured by, quote, an act of international terrorism that is committed, planned, or authorized by a terrorist organization may sue any person who, quote, aids and abets by knowingly providing substantial assistance or who conspires with a person who committed such an act of international terrorism and recover treble damages. So the
Saudi government, 9/11, sorry. It's a weird cough I had. I don't know what it is.
The legal question in the lower courts was whether a social media platform that was not used to commit a specific, quote, act of international terrorism may still be liable for aiding and abetting under Section 2333.
Also, international terrorism, but not domestic. Interesting. Weird that, like, what? Does that not apply to domestic terrorism? What the fuck? My voice is changing. What just happened? I think I had a bubble in my throat. That was crazy. Domestic terrorism is the good kind. Hoggers, Hosh Chud. I love that. Yeah, brother. Domestic terrorism is the good kind of terrorism.
The plaintiffs say that the answer is yes, that Google aided and abetted an act of international terrorism, conspired with the perpetrator of an act of international terrorism, and provided material support to ISIS by allowing ISIS to use YouTube. And of course, the defendants say no, the plaintiffs' claims are barred by Section 230 of the Communications Decency Act, which often immunizes interactive computer services, aka websites, even when they make targeted recommendations. The trial court and the Ninth Circuit Court of Appeals sided with Google, ruling that the claims fell within Section 230, Section C, because ISIS, not YouTube, created or developed the relevant content. The court said that YouTube, quote, selects the particular content provided to a user based on that user's inputs. The display of recommended content results from algorithms that are merely, quote, tools meant to facilitate the communication and content of others, and not content in and of themselves. As the lower courts noted, the recommendations are based on the user's preferences, not YouTube's. The plaintiffs argue that Section 230C does not apply to, quote, activities that promote or recommend content. So let's dig deeper into what all of this means. First of all, the plaintiffs are not simply arguing that platforms are liable because terrorists have used their services. They argue that the powerful algorithms that recommend content are not covered by the CDA because the recommendations are content in and of themselves. And as the Ninth Circuit said, the complaint alleges Google uses computer algorithms to match and suggest content to users based upon their viewing history. The Gonzalez plaintiffs allege that in this way, Google has recommended ISIS videos to users and enabled users to locate other videos and accounts related to ISIS, and that by doing so, Google assists ISIS in spreading its message. So the plaintiffs claim that YouTube facilitates communications between ISIS and people who watch their videos, thereby aiding ISIS in recruiting new members. The plaintiffs acknowledge that YouTube removed ISIS videos and suspended or blocked ISIS users at various times. However, the plaintiffs claim that YouTube should have been able to stop ISIS from re-establishing the accounts using new identities. And the plaintiffs allege that Google left some of the ISIS videos up because they did not contain content violating the site's policies. At other times, Google removed the offending content, but did not suspend or ban the accounts. Now, we've talked about Section 230 of the CDA many times on this channel. Section 230 was created back in 1996 at the dawn of the internet. It has two key provisions. Section 230C1 says, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This sentence is often called the 26 words that created the internet. This section stipulates that providing access to third-party content does not make an online provider the publisher or speaker of that content. Now, the second major part of the law is Section 230C2, the so-called Good Samaritan provision, which states, quote, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So this provision gives online platforms broad immunity from liability if they moderate content in good faith. This provision was meant to allow websites to police itself without incurring new liability because it was an issue of knowledge. A website might not know what speech was hosted on that particular website, in which case they wouldn't be liable for it. But if they knew that illegal speech or defamatory speech or some other kind of speech was hosted there and then took steps to remove it from the website itself, then they actively had knowledge of that particular speech and thus might become liable for hosting it in the future. So websites found themselves on the horns of a dilemma until Section 230 of the CDA was passed to allow them to engage in good faith moderation. Because there was generally a knowledge requirement to be liable for things that were hosted on your website. If you had no knowledge of what kind of speech was on your website or platform, then you generally weren't liable for it. But the argument went that if you started to moderate your website, then that was evidence that you knew what was on there, and therefore you became liable for all the stuff that you were trying to remove from your website. And this applied to spam, to pornography, to pirated media, to defamation, you name it. So the CDA was enacted in 1996 when the internet was still in its infancy. At the time, companies like America Online, CompuServe, and Prodigy were the portals that allowed people to access the internet. People could share files, exchange messages, and chat with each other in real time. But that posed a dilemma. Who would be liable if a user posted something defamatory or shared something else that was illegal? Would liability go beyond the person that was responsible for the post? Or would the internet companies who hosted the content also be on the hook? And that brings us to the distinction between content publishers, distributors, and platforms, which is often completely misunderstood. In the pre-internet age, publishers, distributors, and platforms were treated differently under the law.
This seems like a way to stop right-wing radicalization. Am I wrong in kind of supporting this? Well, as Michael from Pennsylvania, also known as Central_Committee, correctly pointed out, there's like good and bad to this regulation. It's about like how it's implemented and who gets to implement it and whether they implement it at all. Now, the good of it is, you're right, that technically NetsDG and other regulatory mechanisms that hold platforms accountable are supposed to stop Nazi propaganda, for example, or hate speech from happening on platforms. The issue, however, is that it's weaponized regularly against people who are not violating the platforms. TikTok does a very horrible fucking job with this kind of moderation, as you've seen. And then if the platforms themselves were held liable by governments or allowed to be sued for the kind of content that they have, okay, then platforms fearful of any kind of UGC would be forced to basically promote only like corporate acceptable, like nothing that pushes the boundaries type content that is like already pre-cut. It's similar to your point about the New York Post story about Hunter's laptop being taken down. Selective moderation is a slippery slope. I mean, you could argue that the provision doesn't protect the algorithms made to boost content. The Supreme Court could rule that the moment that an algo picks it up, then the liability is on the platform. First of all, you would need these geriatric fucks to know what any of those things mean or how to fucking figure that out, which even their clerks are not going to know. That's number one. And number two, I don't think that then you just don't boost anything. Then you have then you have basically like 30 viewer Andes that want to go viral, but like they will never get viral because they don't have content that is pre-moderated. It's interesting. I don't know how to solve it. Like, I'll be the first to admit that. I don't know.
Publishers were newspapers, magazines, and broadcast stations. They were generally liable for republishing material from third parties since they solicited the things that they published and they could vet those materials. Distributors were businesses like bookstores, newsstands, and libraries, which distributed material that was printed by others. And distributors were not required to assess every book that they sold. For example, in the 1950s, the Supreme Court overturned a Los Angeles.
You're talking like going viral is something we're owed? That's such a fucking stupid take if you don't understand what the other side of that is. You are in here every day. You see how much misinformation can be damaging and devastating. Okay? If our corporate oligarchs are the ones who even full-blown control the information that is being disseminated on their platforms, you bet your fucking ass I'm gone, okay? No longer do I have the Hasanabi broadcast. The moment that I say something about Jeff Bezos, they're like, well, you're technically a liability. Sorry. You could be saying things that are considered to be radical. You know what I mean? It's just like you're not going to have any new content creators. You're not going to have any content whatsoever. It just dramatically changes how the internet works, how independent media works. Because right now, as it stands, the way that the algorithms are operating are not good. I agree. Because it is more interested in keeping people on the website rather than looking at the content and having like any kind of ideological perspective on it. Their ideological perspective basically comes from not having an ideology on right-wing shit. Okay, bro, we get it. Stop fucking, oh my God. Sorry. Not having an ideology. Just, my brain is fucking broken. Oh. I don't know. I feel like it would just be corporate bullshit. It would just be fucking corpo bullshit. Like the only news you would get is ABC. No more independent media. None of that shit. You don't get to see it. You don't get to grow it. You don't get to have a platform that grows it. You don't even have any platforms, not just Twitch, not just TikTok. You don't have a single fucking platform to go to like independently grow your audience. You're just cooked. You're telling me nothing went viral before recommendation engines? It did, but it was pure organic vitality. First of all, that's not really true either. This is similar to making gun manufacturers liable. Yeah, I don't have an issue with making gun manufacturers liable because communication and free speech is an actual fucking principle that I think is important, especially when it comes to disseminating information. Whereas having a fucking gun is not your like God ordained right. Anyway. That guy in the hole went viral a long ass time ago. Yeah, but there was an infinite amount of things that, first of all, that guy in the hole went viral because news media covered it. Today's news media is the internet. So like, you know, what you're saying is the only things that should go viral are things that the media considers to be viral. The media thinks is important. I mean, you saw the Ohio stuff. The Ohio thing would have never gone viral if it wasn't for the kind of content that you get recommended and the kind of content you see. Everything that you consume that you take for granted is also beholden to an algorithm. You get it? That's it. Like the top of the hour ad break, which comes at the top of every hour, and it's 3 minutes long. You are beholden to that because of an algorithm. Okay? That's it. And if you no longer want to see those ads, all you need to do is subscribe, which you can do for $5 or for free with a Twitch Prime by connecting your Amazon Prime account to your Twitch account, where you get one free Prime subscription a month. Yes, I will be playing Atomic Hearts later. You can also get gifted a sub if you're lucky. Here's the 3-minute ad break now. Thank you to the anonymous user for gifting 10 Tier 1 gifted subs.
Ordinance that said, if you have obscene material in your bookstore, you can be held criminally responsible. And in that case, a bookstore owner was convicted of violating the ordinance by selling a novel called Sweeter Than Life, which tells the story of a, quote, ruthless lesbian businesswoman. The Supreme Court said that the bookstore couldn't be responsible for reviewing every single thing in the book or magazine that it sells. And distributors only had liability if someone notified them that something they carried was illegal. That's sort of the origin of
the algorithm itself, however, is not like carrying the book, but instead like literally putting the book in a certain subsection. Like maybe I can see the argument of it being basically like, I don't know. I'm such a radical centrist on this. It sucks. Whenever it comes to free speech issues, there are like certain things that I personally understand and will advocate for. Okay. But as far as like certain issues that revolve around like communicating or controlling the dissemination of information, distribution of information, I immediately think of the worst possible outcomes. And it's not from a nefarious point of view. Because I see literally both sides. You know, I see both the arguments for the good and the bad. And I see the current application of pre-existing regulation, and it falls short of what is necessary. Is it because your money is wrapped up in it? No, dude, if there are plenty of things I want to say that I don't say on a daily basis, my friend. I already self-censor, okay? Trust me. it would be fine. I would find a way to, promote my commentary as I currently do through the most TOS friendly ways I possibly can. Now, of course, I still sometimes say things in emotional moments, heated gaming moments, that are in violation according to the terms of service. Can't be saying those gamer words. No, it's not gamer words, but like tokens, like I talked about, like the kiss yourself token that I think is just sometimes I just want to really say it. Okay, I really do, and I want to say more. I want to say more than that, but I can't. And I hold myself back, and I understand why that kind of terms of service regulation exists. I have time and time again also mentioned that Twitch has the best terms of service application. Like it, hate it, it's vague, it sometimes fires off inappropriately, but it still absolutely has like actual terms of service that it abides by and holds creators to account on. It's true. In comparison to YouTube, in comparison to Facebook, in comparison to Instagram, Twitch actually has a TOS, and it's significantly better than other platforms. This I will absolutely openly admit. It's not Corpa Arc. That's so stupid. I get banned more than any other content creator, you fucking idiot. Oh my God. I hate when people say this is your Corpa Arc. Kappa? That's not your... Yeah, okay, you're a dumbass. You're an actual fucking dumbass if you think that. All of your faves have gotten banned for shorter periods of time than me or less than me, okay? Just remember that. And I've been stating this before I got banned, and I've been stating it even after I get banned. Okay, no matter what happens, I don't like Twitch Corpa, and no, you too. What? Motherfucker can't even talk. He just keeps saying Corpa. Like, you just keep saying Twitch Corpa. Like, your brain is already rotted from Twitch, dude. Maybe you should just tune out. You never mentioned Twitch Turbo? Yeah, fuck Twitch Turbo. They could suck me. No, fuck that. Anyway. What about social media's role in spreading hate? I think social media plays a significant role in right-wing radicalization and domestic terrorist incidents that occur. I agree. I think that social media should be very careful in promoting this kind of thing. The platforms should definitely control it. The platform should definitely have a stronger hold on terms of service violations, like Twitch does. Okay? Lest they want the government to come in and check them. But they don't. You know what the funny is? The guy who complains about you getting the most favoritism hasn't been banned since like 2019. Are you talking about like Trainwrecks or something? Because like he doesn't even stream that much anymore to get banned even. But yeah, you're right. That's right. I've been banned more than XQC. I've been banned more than Trainwrecks. I've been banned more than most other top content creators. A lot of the top content creators that are gamers, right? Like they're gamers with a fucking capital G and a hard R. None of them ever get banned, really. They usually don't. It's true. Oh, even though I get favoritism, I don't think you should hate on Turbo. I use it for a good viewing experience. Yeah, okay. I hate on Turbo because like, why the fuck would you give money to the platform instead of the content creators? That's why I hate on Twitch Turbo. You know what I mean?
the knowledge requirement. And platforms were common carriers like phone companies and television broadcasters. Platforms weren't liable for third-party content that they carried. So, for example, let's say AT&T found out that someone's answering machine had a libelous outgoing message. Was AT&T required to act by canceling the owner's telephone service? Well, the court said no, AT&T couldn't be sued for libel simply because the owner used its service to say something libelous. And similarly, a broadcaster wasn't liable for running a political candidate that falsely accused someone of being a communist. But then the internet came around, and the internet era posed a new challenge for this case law. Two of the first internet service providers, CompuServe and Prodigy, were sued for hosting forums where users posted defamatory content. Now, Prodigy billed itself as a family-friendly version of the internet.
Did you get a computer recently? Well, congratulations. You can now join hundreds of thousands who've discovered Prodigy.
It moderated comments, removing things it thought were bad. Now, CompuServe didn't moderate anything.
CompuServe combines the power of your computer with the convenience of your telephone.
And both of those companies were sued for defamatory statements that their users posted to the service. Now, the case against CompuServe was dismissed because the court considered it a distributor of content rather than a publisher. CompuServe could only be held liable for defamation if it knew or had reason to know of the defamatory nature of the content. And since they didn't do anything to moderate their forums, the company couldn't possibly know, or at least argued it couldn't possibly know, about what the denizens of Rumorville were posting about each other. But Prodigy was found liable for failing to moderate enough. Someone went on a forum and claimed that Jordan Belfort's investment firm, Stratton Oakmont, committed fraud in connection with a stock IPO. The firm sued Prodigy and the anonymous poster for defamation, and a court held that Prodigy was liable as the publisher of the content created by its users.
Wait! What? But they did! Wait, didn't they? Bro, that's... What?
Since it exercised editorial control over the messages on its bulletin board. Now, if the names Jordan Belfort and Stratton Oakmont ring a bell, that's because they were literally scamming people out of millions of dollars and have gone down as some of the biggest fraudsters in all of Wall Street history. The movie, The Wolf of Wall Street, is based on the fraud that they were perpetrating with respect to the IPOs. And it's one of the biggest ironies in all of First Amendment law that they won this lawsuit against the people that were hosting presumably accurate information about.
That's so crazy, bro. Oh my God, I did not know this. Oh my God. I did not know this lawsuit component of the fraud. Oh God, our fucking this is why this court system is so broken, bro. They literally fucking successfully sued a website for hosting information. They sued a website that has a terms of service that it abides by. Okay? And not a website that doesn't have a terms of service, so like it lets shit fly off its fucking hinges because, hey, we don't have a TOS. We don't have any control over what's going on. Meanwhile, the website that was, the website that had a terms of service was successfully sued for hosting content that was objectively truthful. Japan-type defamation lawsuit. Yeah, literally. It's like calling Hasanabi a bad gamer than him suing Twitch for me for defamation, and when everyone knows it's true. Yeah, literally. That's actually surprisingly a good fucking take.
About how they were scamming people out of money. That's part of the problem when websites are liable for user content, is that people can file lawsuits to stifle speech. That's what a slap lawsuit is all about. And because lawsuits are incredibly expensive, sometimes even if you scammed people out of money, as long as you file a lawsuit, you can stifle that kind of speech. But I digress. As a result of these cases, internet service providers basically either decided to not moderate at all and leave absolutely everything up, or basically moderate everything and not allow anything to go up. And basically no one was happy with this state of affairs, so Congress enacted the Communications Decency Act. And then, as now, lawmakers claim to be especially worried about things like harassment.
It's pretty funny to have like signature legislation like this, okay, in this day and age. Like, I'm trying to think real hard on like, has this happened in the last like 20 fucking years since 9/11? on anything that pertains to like implementing sane or insane regulatory control over corporations. You know what I mean? Good or bad, really. I guess the ACA, that's like, yeah, that's it. ACA, that's a good take. No, that's fair. The ACA is fair. Yeah. I can't really, and and even then it's like so, like even then it fell significantly short. No, Citizens United is the opposite. What do you mean? It's like, no. That decision is the exact opposite of what I'm talking about. No, I mean like implementing corporate control, not unshackling corporate spending in the form of... No, when I said bad or good, I meant corporate control that's bad. I didn't mean deregulation. I meant regulation that is, shitty. Regulation that's shitty. That is deregulation. Good corporate control. All corporate control is good. All matter of corporate control is good. I meant like it would be weird to find shitty corporate control like this level.
Harassment and obscene material. So they gave online providers immunity from lawsuits if they moderated content. And again, the irony here is that this legislation came from the sort of family values type politicians, the people who always want to think about the children.
Oh, won't somebody please think of the children?
Also, Citizens United was a SCOTUS case.
To
yes,
remove
not legislation.
Violent and sexual conduct so that the internet could be even cleaner.
Corporate control, I don't mean corporations controlling. I mean controlling corporations. Daddy Leon Trotsky, come on.
The same politicians who wanted and got the little parental advisory explicit content warnings put on rap albums. But I digress again. Section 230 was intended as a way for internet companies to create and enforce basic standards to run their websites. And when the CompuServe and Prodigy cases were decided, the courts only considered whether the ISPs were publishers or distributors. But an internet service like a website didn't fit neatly into those categories. A traditional publisher has total control over whether to publish content. A distributor can control what it buys, but it wouldn't have been practical for a human to fully screen every item. Modern social media companies host more material than any library or bookstore on Earth, which makes screening all of that info daunting, if not impossible. And without Section 230, social media companies would be subject to strict liability for every message and post made on their services. So Congress chose to give those platforms and websites immunity as an incentive to get them to remove offending speech. Congress also chose not to dictate to those companies which speech they had to remove. So that brings us back to the original question in this case. How should courts read Section 230? The lower courts follow the test set forth in the Ninth Circuit case called Barnes versus Yahoo, and the Barnes test hews close to the text of Section 230. The law specifies that only 1, no interactive computer service, shall be 2, treated as a publisher or speaker, of 3, content provided by another information content provider, aka users. Now the plaintiffs argue their claims do not treat Google as a publisher, but instead assert a simple duty not to support terrorists. They said that the ATA prohibits Walmart from supplying fertilizer, knives, or other material to ISIS, and in the same way, the ATA bars Google from giving ISIS a platform to communicate. The Ninth Circuit found this analogy specious. The idea of a duty not to support terrorists, quote, overlooks that publication itself is the form of support Google allegedly provided to ISIS, and publication of third-party content is what Section 230 gives to internet services. According to lower courts, publishing encompasses, quote, any activity that can be boiled down to deciding whether to exclude material that third parties seek to post online. Google says that the CDA uses the words publisher or speaker in an ordinary sense. Quote, based on an ordinary meaning, a publisher or speaker is one that publishes or speaks. Google contends that when YouTube's algorithms make recommendations, this activity is protected by Section 230. Quote, Congress underscored that publishing for purposes of Section 230 includes sorting content via algorithms by defining interactive computer service to include tools that pick, choose, filter, search, subset, organize, or reorganize content. Congress intended to provide protection.
this boring boomer still later, dude. Yeah, man. Sometimes trying to fucking understand complicated situations and develop a better perspective requires you to look through some fucking law. And even this is like the most fun way to look at something like this. It's an issue that directly impacts you, by the way. I'm just going to let you know. You know, whether you're a Zoomer or not, it like directly impacts you. You know, I can throw up some Subway Surfers for you on the side if you want to take a look at that. You know what I mean? Here's like motherfuckers, dude. Here you go, bro. Here you go, brother.
Recently, I played Subway. Helps your score multiple.
Here you go. Is that better?
Protection for these functions, not for simply hosting third-party content. And the plaintiffs disagree. Their interpretation of the Section 230C defense is that it requires a narrower interpretation of the word publisher. The Ninth Circuit previously held that Section 230C1 uses publisher in its everyday sense, and the Second Circuit agreed. But the plaintiffs contend that the word publisher is used in Section 230C1 with a narrower and distinct meaning, which that term has in defamation law. Basically, the plaintiffs are claiming that any time YouTube recommends another video, it therefore becomes the speaker of that video, as if YouTube had produced that video itself. Now, defendants say that this interpretation doesn't make sense. Quote, watch the World Series of Poker on YouTube, and YouTube's algorithms might display Texas Hold'em tutorials. That does not mean that YouTube endorses gambling any more than spellcheck endorses a suggested substitute word. Westlaw endorses higher listed cases, or a chat room endorses posts organized by topic. As the Ninth Circuit noted, YouTube applies the same algorithms to all content. And it's here that I think people often misunderstand the nature of the internet and the nature of social media. With the case of YouTube, people upload millions of videos a day. If there wasn't an algorithm to sort through this deluge of videos, the only way to sort through them would be a fire hose of viewing every video chronologically, which nobody wants. It would be that or doing a pointed search to try and find content, but then you'd never be exposed to content that you actually do want to watch but didn't know that you wanted to seek it out. And the plaintiffs have tried to differentiate between search results and other algorithmically generated results, but there's really no principled way to distinguish between results that are sorted when you actively search for something versus results that are presented to you because of a recommendation algorithm. And people love to hate algorithms, myself included. But the truth is, if there weren't algorithms to help us sort through all of the content on social media platforms, it would be impossible to wade through it. And then additionally, there's the issue of the material support related for a claim under the Anti-Terrorism Act. Now, the Department of Justice's brief in support of the plaintiffs argues that algorithmic recommendations convey the website's own implicit message that users will find the information relevant, and that makes the website liable because it's acting just like ISIS itself. Now, plaintiffs didn't claim this in their original complaint. Instead, they focused on how YouTube's recommendations amplified the ISIS speech, making it more visible to more users. But the US government urged the Supreme Court to adopt a narrow reading of Section 230 that would permit a finding that Google materially contributed to the content by matching it to user preferences. Again, basically, the Department of Justice, as well as the plaintiffs, are arguing for a standard that if any website promotes content, uses an algorithm, or recommends content to users, that website then becomes liable for all of the speech contained within that recommendation. What happens when websites are liable? Well, remember I mentioned that this has actually happened before? Well, it has. In 2018, then President Trump signed into law 2 bills making it easier to fight sex trafficking online. That was the Fight Online Sex Trafficking Act and the Stop Enabling Sex Traffickers Act, otherwise known as FOSTA and SESTA. And those 2 laws created an exception to Section 230's safe harbor rule by stating that websites could be held legally responsible if third parties posted ads for prostitution on their platforms. The law penalizes websites which, quote, promote or facilitate prostitution. And while this includes sites that promote illegal sex work, it also allows the police to investigate any site that is knowingly assisting, facilitating, or supporting sex trafficking. This language can be read to include sites with content that is legal, such as escort services, personal ads, and pornography. Now, critics of FOSTA and SESTA warned that the new laws were too broad and they would end up killing internet content that has nothing to do with sex trafficking. And they turned out to be correct. If a third party posts content that is covered by FOSTA or SESTA, and the website fails to prevent that content from being posted, that website can be sued. And that was simply too much legal risk for several websites.
You should have gone for the head.
Craigslist shut down its entire personal section. Tumblr banned all adult content, and Reddit removed several subreddits, and other websites just simply shut down entirely. So you might ask,
like, as you can see, there's some good, banning certain subreddits, and some bad. The issue was, for sex workers, it made it a less safe space. Like, none of the websites that worked to help sex workers, work to create client lists, work for sex workers to consistently talk to one another about like certain clients that were dangerous, whatever. It basically eviscerated those websites. The exodus from Tumblr to Twitter objectively made the internet worse, says one chatter. They are correct. You know what I mean?
Ask, did any of this assist with the prosecution of sex trafficking? Well, in 2021, the U.S. Government Accountability Office released a report on the first 3 years of FOSTA and SESTA, finding that, quote, over 3 years, the Department of Justice filed just one case under its rules against promoting or recklessly disregarding sex trafficking. So ironically, this provided essentially the perfect natural experiment to find out what happens when websites are liable for the speech content of its users. One of two things will happen. Either the website shuts down that section or shuts down the entire department, or the website employs an army of moderators to remove anything even remotely offensive. You basically either live in a world where a website allows everything, scams, spam, pornography, ultra-violence, just everything that you can possibly imagine you probably don't want to see in your everyday life, or you live in a world where they employ extremely expensive moderators who prevent anything that might possibly be offensive. And that, of course, assumes that a website can even afford to employ those moderators. So there are those who want to see Section 230 modified or scrapped altogether, and have argued that these online services are acting.
Are these people anti-sex work? Are they trying to do good? I mean, honestly, in a lot of instances, all matter of like anti-sex trafficking legislation is just basically anti-sex work legislation. But anti-sex trafficking is obviously a justifiable, understandable thing. But they're basically just fulfilling their desires of banning and making it harder to do sex work. That's just how it works. It's just phrased in a way that is like anti-sex trafficking and anti-sex slavery. But it's usually just anti-sex work. Like they purposely blur the line between sex work and sex trafficking. Something that a lot of swerves do regularly. Which, for the record, sex trafficking is a legitimate problem. Okay? Obviously. Problem is, anti-sex work legislation that paints all sex work as sex trafficking creates a system where it makes it even harder to differentiate between sex work and sex trafficking. Sex work is still going to happen regardless, and it does, and it continues. It just, turns it into less controlled, less regulated sex work. That's the issue. Makes it harder for the sex workers to engage in consensual sex work in a clear, coherent, consistent, safe manner. And it also makes it harder to, if you're regulating sex work that's consensual in nature between adults, then you're spending resources against sex workers rather than people who are trafficking. people who are kidnapping and forcing people to do sex trafficking. You know? That's just, because there's a lot more consensual adult sex workers that are doing it, even though they're doing it in less than legal means, right? So everyone hyper focuses on what they can get away with, like who they can prosecute. Being pro-sex work is cringe and liberal. Swerves rise up. Dude, imagine being in this fucking community for 41 months and still fucking saying swerves rise up. Like, it's so fucking stupid. You're just an idiot. I mean, actually. Yeah, you're such a based trad ML, dude. No, there are a lot of people who disagree with me on this, especially in leftist communities, and they become increasingly unhinged. It's like usually femcells who fucking behave this way. They're just like psychotic about it. Yeah, trad ML, Gigahos. Yeah, dude, it's so trad to be on fucking Twitch and post Gigahos in the chat. You're the most trad. Also, you know what's fucking trad? Sex work, dummy. It's older than your culture and anything in your understanding of the fucking world. Literally, it's like the most ancient tradition. So if it has happened throughout time, if it's happened throughout the existence of humanity and it will continue to fucking happen, why not make sure that it happens in the most consensual work? I mean, I'm anti-sex work. There's no consensual sex work under capitalism, but like, what do you mean? Like, all labor is done under coercive conditions under a capitalist organization of the economy. Sex work is the exact same concept. It's the sex that you have an issue with, not the work part. All work is. And if you ever talk to like adult sex workers, okay, like grown ass fucking sex workers that have been doing this for many, many years, they will tell you they find emancipation and more autonomy in doing sex work than they do working at fucking McDonald's. You know what I mean? But sex work is more traumatic than regular labor, or else being punched would be the same as the R word, right? Being punched? I mean, people are being punched for their regular labor, okay? People also are, giving massages to people as a consequence of their regular labor. What the fuck do you mean? If someone is consenting to have sex with someone else, whether it's for money or because they like really want to fuck, okay, they're horny, or sometimes both, all you're doing is basically legislating away a person's right to be able to do so. I agree with the take, but something being old does not legitimize it. That opens the way to justifying slavery and other unhinged things. Yeah. But that's not the only reason why I justify it. You have to look at the output. I always fucking say this. Look at the output. Okay? Slavery is not consensual. Consensual sex work exists. What the fuck? You'll never win with a chat like this. They mean to say all sex under patriarchy is unethical. Yeah. It's just we're American. We're American. It's very, very difficult for people to understand. People cannot comprehend sexuality. People cannot comprehend sexuality outside of their own narrow definition of being sexual. That's another thing. It's like a very deeply personal thing. I'm also on board with having additional checks and additional safeguards on platforms that have sex work. I personally perfectly understand the need for that because I do think that it's a little bit different. I'm not sitting here and saying serving you a fucking hamburger at McDonald's is the same as getting fucked on camera, okay? It can be liberating for some. Some people might do it under more coercive conditions, however. And in order to eliminate that, I do understand that these websites have to be super fucking careful. That's why that exodus happened on Pornhub, where they got hit because they were just hosting whatever kind of fucking content that people wanted to host on it. Okay? And that's inappropriate and will lead to a lot of unethical and unhinged content on that fucking website. Okay? So I do think that it's perfectly valid to have extra circumstances. Implicit in this take is that no one wants to do sex for money, which is provably false. Exactly. You don't think anyone wants to do sex for money. You cannot comprehend a world in which someone is like, yeah, I'll fuck this person for some money. Like, it's great. Maybe I want to fuck this person. Maybe I don't care about fucking this person. Okay? And they're going to give me money, and I like that. And by the way, that is the highest, like, that's the most, like, in contact form of sex work that we talk about, prostitution, right? Which is why I'm using that. But there is, like, an infinite world of possibilities before you get to that. Okay? Before you reach that level. And people that are anti-sex work oftentimes eliminate and eradicate every other aspect of it too. But that's it. Chatters act like it's inconceivable that someone would rather suck a dick than regularly get hot oil burns in a fast food kitchen. Yeah, in their minds, people never think about it. In their minds, people never think about it in like ways that it could be consensual because they can't comprehend it being consensual, especially when a transaction is involved. Okay? They can't see it. They just literally cannot comprehend a world where people are just like, no, I love fucking, and I love fucking on camera, and I think it's good, it's cool, and I want to make money doing this. You know what I mean? They just can't comprehend that. So they're like, it must not happen. It surely does not happen. And then they think of the very real instances where someone is not consenting and say, this is exactly what it's like, actually. And it gets reinforced in their minds that it's always rape, it's always rape, it's always coercive, it's always fucked up. Because it can't. The positive aspects of it cannot exist. So then they look to plenty of examples of like ex-sex workers that turn swerves, for example, to, again, highlight and reinforce the cognitive biases that they started off with. It's just, again, reactionary thinking where you cannot have your mind changed and you cannot see a different perspective on the matter. So you immediately rush to find ideas that reinforce your pre-existing biases. TERFs do this, and many understand it. Swerves do this, and some people don't, because a puritanical attitude is baked into our core, our very existence from the jump. And then they look to absolutely the worst examples that do exist. And they paint the entire group of individuals with the same brush. And it's very annoying. It's very frustrating. I'm not one of those people who's like, oh, dude, sexual liberation, like across the board, all the way. You know, I like the mystery of certain elements, certain components. Okay. I think it's a very personal thing you can do. Okay. I get that. I understand that. But if someone doesn't want to maintain its private elements, if someone wants to make money off of it, I see no difference between someone literally doing any kind of acting on camera. POV, you made $17 in a half year doing sex work and now you're a swerve. Yeah, literally. Yeah, sex work doesn't even automatically mean sex either, like fucking someone either. It just, you can literally post titties. You mischaracterize the swerve argument a lot, though. The element of coercion is always there if money's involved. The element of coercion is there for every facet of existence. You exist under capitalism. That's the point. I don't mischaracterize that. I recognize that. Okay? There is a level of coercion in everything that you do under a capitalist organization of the economy. If not, the coercive component of the structural violence of poverty. You don't go to work because you love your fucking work, but you can, right? You can love your job, but you don't go to your job because you love your job. You go to your job because if you don't go to your job, you don't have health care. If you don't go to your job, you don't have a roof over your fucking head. You get it? So Scum Eva says, I'm a chef. I make a quarter that doing sex work. And if you ask me, sex work is harder than being a damn chef. People always say, under a communist utopia, wouldn't there be sex work? And it's like, what are you going to do? Are you going to stop people, even if they have all their needs met, from wanting to make art, if they consider that to be art? You know what I mean? Because you're like, no, it can't happen. It's so stupid. I'm late to the discussion. Why are people questioning the validity of my life as a sex worker? I mean, you're a sex worker, so you already... so that's not necessarily a new conversation. It's one that we just don't really have here on the broadcast as much recently because I just don't talk about it recently. But anytime I bring up sex work, you got a bunch of fucking Marxist-Leninists chiming in being like, no, it's fucked up. And when you have a community as progressive as this one that still has a fuckload of anti-sex work sentiment, fuckload of anti-sex work takes, right? Where it's at its best still laughably patronizing, right? Where people will just literally be like, no, you don't understand, sweetie. We're trying to defend you from yourself. You're making a bad decision. You know what I mean? Like at its fucking nicest, at its most normal, anti-sex work sentiment literally still destroys the autonomy of the sex worker itself. Why are MLs typically anti-sex work? I don't think MLs are typically anti-sex work, but there are a lot who are. You know? Because they are, what is an ML? Marxist-Leninist. Sex work isn't consensual under capitalism. Most labor isn't. You still have to support sex workers the same way you support labor. It's really not that hard. We agree in principle. Anyway. NFL players and UFC fighters get concussions for entertainment, but we don't moralize it. Some people do. The difference is NFL and UFC is considered a major fucking industry where people have where people who are in control of that industry have an insane amount of power, and there is no fucking cultural attitude that dictates that like combat sports or like aggressive sports where people actually do get fucking concussions regularly is wrong and immoral in the same way that like having sex is wrong and immoral. There's no like puritanism that has decided that combat sports is fucked up. Also, ultimately, if we're looking at literally the people that are doing the work consensually, NFL players and UFC fighters that are consensually fighting still get damaged significantly worse than sex workers do that are doing it consensually. They're both exploitative. One of them caters to mainstream America. I mean, one is literally less exploitative even. A lot of MLs think of sex work as like post-USSR kids having to or else. Yeah, exactly. It's just there is no genuine understanding of it. I think it's just, bro, 90% of the ML subs support sex work, like very outright. I don't know if there's a good take. It's just conservative lefties who like the aesthetics but are hyper online and take shit too literally. It's also a lot of fucking Zoomers. A lot of Zoomers have this whiplash from the Tumblr era, like sexual liberation, where and maybe just like watching porn non-fucking stop, having like unfettered access to pornography at a moment's notice. And I don't know what the fuck happened to their brains as a consequence of that, but they do legitimately fucking ride for the repression of sexuality and the repression of like sexual liberty. Like it's like the new hip thing, like it's disruptive. How would you describe sex work in the global south, especially regarding sex tourism? I can't speak on it because it's not something that I have a lot of experience with or knowledge over. I don't know. I really don't. Yeah, it's like seeing Zoomers being like, let's not have any sex scenes in movies. But yeah, Zoomers do legitimately think like because all they've seen is like liberal mainstream media and other shit like that on the internet, this like overall liberal attitude, that they literally thinking exactly like their grandparents did about sex work is actually disruptive and subversive. I always say this. If you have a problem with sex work and you think sex work is not real work, then you have a problem with the sex part of it. Even as a leftist, even as a Marxist-Leninist, that's just how it is. You differentiate sex from everything else. I don't know if it's because I'm in a hyper queer space, but most Zoomers I know are pro-sex work. No, there's a lot of Zoomers who are openly pro-sex work. There's a lot of people who do sex work. OnlyFans really changed the game, especially in the Western world in regards to how people view sex work. I think you are describing radical feminism, not Marxist-Leninism. I mean, I think that there are radical feminists who are Marxist-Leninists who end up having this kind of attitude. There's also, again, puritanical ideas that cause people to fucking view sex in this regard. You can support sex workers while also having a material analysis on issues faced by the vast majority of sex workers who are putting their lives at risk every time they go to work. Most places in the world, it's one of the most exploitative and most dangerous industries that exists, especially for women. Yeah, I 100% agree with that, which is why I support sex workers, which is why I literally don't fucking allow anti-sex work sentiment to just fucking rip through this broadcast in the same way that I would not allow anti-trans sentiment to rip through this broadcast. So yes, and the irony is always that swerfs who are not just against sex work that is non-consensual, but sex work that is totally consensual, make it an even more dangerous space. There's an old Lenin quote about sex work that some MLs latch onto. Yeah, I don't give a fuck. It's so stupid. It's so fucking stupid because like it completely betrays any kind of like current analysis that you can apply with the basic principles that you're supposed to be applying to contemporary issues by literally just highlighting, mythologizing, and romanticizing about a time and place without factoring in current material conditions, current modes of existence, current cultural analyses. Like, you literally are just only romanticizing about a fucking past that never existed, okay? I will never sit here and tell you not to read Lenin, okay? You definitely should. But it is so fucking silly. It is so incredibly silly when people just don't even think about what these concepts are and just blindly hyperfixate on a romanticized version of revolution, stuck in a time and place without ever understanding what came after, without ever trying to think about what could be done better. So yeah, it is what it is.